Thank you for your patience. I'm going to be toggling back and forth. So the calendar, 2:00 calendar, position 1, Michael Weems, motion for reduction of bond. Are you all going forward with that?
Yes, Your Honor, the state's ready.
Position 2, Eddie Sanders.
That's the same as well, Judge. That's also mine.
Position 3, Jose Cruz Rodriguez.
Good afternoon, Your Honor. That will be a consent this afternoon, and I will be signing with express permission for Mr. Edmonds. So I just need a minute to type that up, and then we'll send that over.
Okay, very well. You're free to leave. Thank you.
Thank you, Judge.
Position for Shane Smith, motion for bond.
That is mine, Your Honor. We are ready to proceed.
The state is ready as well.
Let's have Michael Weems, please.
Good afternoon, Judge.
Is he, who needs a Spanish interpreter?
Your Honor, that was for my case, for Jose Cruz Rodriguez.
Okay.
As we're no
Mr. Edmonds and Ms. Bermudez, you both are free to leave. I've just been advised that that is a consent.
Yes, ma'am.
Is
Thank
that
you.
correct?
Yes, Your Honor. Thank you very much.
Thank you guys for your patience. Have a good day.
You
You
too.
have a good day too.
State of Georgia versus Michael Weems, case number 2018 CR 02947. Mr. Weems, go ahead and raise your right hand. You solemnly swear or affirm the testimony that you're going to give to be the truth, the whole truth. Leave your hand up under penalty of perjury. You solemnly swear or affirm, sir?
What you say?
I can't hear you.
I didn't hear what you said.
Do you solemnly swear or affirm the testimony that you're going to give today shall be the truth, the whole truth under penalty of perjury?
Yes, ma'am.
Lower your hand. Mr. Manetis, this is your motion for, I'm sorry, is this your motion? Whose motion is this?
It is mine, Judge.
Okay.
It was,
This is your motion for reduction of bond. You may proceed.
yes, Judge. When I filed the motion, I was under the impression that Mr. Weems had a bond on his charges in the aggregate amount of what I thought was $100,000, but he's let me know that he thinks there might be some charges where he doesn't have a bond. And I wanted to clarify that before I got started. What is the bond status that the court shows?
Your Honor, I believe I was showing $150,000, but if I could have just a moment to double check.
Mhm. I have on my order from April 21st that the motion for reduction was denied based on his bond of $150,000.
Okay, I just wanted to make sure that's an aggregate amount for all of his open cases. There isn't any charges without a bond, if that's correct.
There is nothing since April 21st, 2020. I presume there has not been any true bill
Okay.
against.
No, Your Honor, but in the clerk system, it doesn't look like he's being held on all of his charges, so a bond may not have been set on
Okay.
a number of these. But the state's position was that it was $150,000 across all charges.
What isn't he being held on?
He, from the system I'm looking at, looks like counts 7, 6, 11, 12, 13, 14, 15, 16, and 17 do not have a bond set on those.
Okay. All right, Mr. Benettes, with that in mind, go ahead and present your motion.
Yes, Judge. With that in mind, even though I filed it as a motion for reduction in bond, I guess I would want to be heard it as a motion to modify bond to at the very least, have it be an aggregate amount of $150,000 on all of the charges. It seems like if he was deemed not a significant risk on the bond factors for one count, that it wouldn't be any different for any of the other counts. But I also know that the family is unable to pay that high amount of a bond, and I understand it was denied when I asked to be reduced earlier, but it has been a while since, the recession and the economic impact of the pandemic just continues to make it more and more difficult for people to make money. So I think that with that large of an amount before the pandemic and back in April of 2020, when it was still kind of getting started, that, an amount of 100,000 would be equal in value in terms of the, purchasing power of that money. It is harder to come across money these days. And so I think that, bond being meant to ensure the defendant's presence back at court, I think that if in the past, in April, 150,000 was going to ensure his presence, I think now 100,000 would definitely ensure his presence. And I'm unaware if his family can even, deal with that, but I think that they could at least maybe stretch and try, but the 150 is definitely completely out of reach. And so we would just ask for an aggregate bond in the amount of 100,000 on everything, given that, the circumstances outside of the jail have changed so that it is a lot harder to come across money, and it's harder to get a job and to maintain a family and all of that. And so his family will try, but $100,000 now after this past year since April has will be enough to ensure his presence back at court. And so that's what we're asking, Judge, $100,000 on everything that's open right now.
Okay, Ms. Miller, what do you say?
Your Honor, the state is opposed to a reduction. I know the court is familiar with the facts of this case, having heard them before on a prior bond reduction, but if Your Honor will allow me to just place them on the record at this hearing. This case arose from a December 27th, 2017 incident in Clayton County, where this defendant, as well as another individual who has not been apprehended, approached Kiana Jones with a firearm while she was moving her car from in front of 271 Brookview Drive in Riverdale. They approached her with a firearm, demanded the car, and made her get out of the vehicle. At approximately 7:15 that same day, they then drove the vehicle to Mattress for Sale at 6598 Highway 85 in Riverdale, entered the location. The unapprehended individual fired a shot into the air. The defendant then took the firearm from that individual, pointed the gun at a Corey Gist, and demanded money. Mr. Gist gave them $120. They took his cell phone and left the location. A few minutes later, at approximately 7:19 p.m., both suspects then entered into Angie's Beauty Supply at 6622 Highway 85 in Riverdale. The other individual again fired a shot into the air. This defendant again took the firearm from him and then demanded money, this time from a Thomas Weaver. Mr. Weaver then threw a stool at the defendant and ran away. The defendant chased Mr. Weaver, fired 2 to 3 more shots in his direction. At that point in time, the other individual took Mr. Weaver's cell phone. Other employees at the location, including a Jason Kim and Cassandra Garza, as well as customers, were in the store at the time, and they did observe that incident take place. The defendant was then apprehended the next day on December 28th of 2017, driving the stolen vehicle that he had taken from Miss Jones and still wearing the same clothing that he had been wearing during the robberies. Your Honor, he did have criminal history as well prior to this incident, a 2015 robbery charge, as well as a 2018 criminal trespass that he pled to after this incident. Your Honor has previously heard this case, as I stated, on a motion for bond reduction from April 17th of 2020. Your Honor did at that time find that the defendant posed a significant threat to the community, as well as individual citizens and commercial establishments, and that there was a significant risk that he will commit another felony pending trial. The state's position is that based on the seriousness of this series of events that the defendant took part in, those concerns would still be here for this case. We're asking that the bond not be reduced. And just so the court is aware, we are ready for trial. This case was in a ready for trial posture just before the pandemic started, and the state's position is that we would be ready to take this case to trial as soon as that is available.
Mr. Menendez, you have closing on your motion.
Yes, Judge, I'll just say that that's all, left to be proven, and that was all known when the $150,000 bond was set. So it's really just a matter of money, not, seriousness. Those would be arguments more for denying bond altogether, but he has been deemed safe under the bond factors to return to court, and bond is not meant to be punitive. But over this past year, he's been unable to pay it. And so just his inability to pay and the changed economic circumstances, I think, do warrant a lowering of the bond, at least not, down to something like 20,000, but something like 100,000, which is incredibly serious in terms of an amount. He would have to pay about $10,000 to a bonding company, and it would be all the money that he and his family have. And so, yes, there are serious allegations, but I'm not asking for a non-serious amount. I think an amount in the aggregate of 100,000 would be enough to, preserve the purposes of bond, of which he has been granted a bond on charges in the indictment for some of the counts and not others. And so that's just what I'm asking, Judge, is 100,000 on everything. And given that he's already been deemed safe to have a bond, I don't think that's too much to ask. And it is a incredibly serious an amount for a serious case.
Okay, I'm going to spread the 150 across all counts. Tell me what was missing.
Your Honor, it was counts 6, 7, and then 11 through 17 were not included.
Okay, so still going to be 150, but I'll spread it across all counts. Give me a moment, everybody. Mr. Williams, you can go back. Probably next. Okay. Not right now. Give me 1 second, okay? All right. Eddie Sanders. Motion for reduction of bond and demand for speedy trial. Mr. Menendez, is that a new demand for speedy trial?
Yes, Your Honor, it is. We had filed one before one had been filed, I think, when I was previously retained. And then we had withdrawn it so that I could prepare and investigate and get ready for trial and thinking that we were next up. And then it ended up that the pandemic happened. And then we never renewed that demand. And now that the Supreme Court seems to be opening things back up in terms of filing deadlines, I just thought it would be appropriate to put that back in. And Mr. Sanders has instructed me to demand a speedy trial again.
Okay, you have a motion for reduction of bond. Go ahead and present your motion.
Yes, thanks, Judge. I think this is the case where I believe Mr. Sanders has a bond in the amount of $100,000. It stems from this workplace sexual assault allegation where actually the complainant was totally aware of this major lawsuit that had been settled against the company. And so my understanding is that she's shortly joined this company. Mr. Sanders is a sort of a middle supervisor, and she alleges that she was raped, but what actually happened was this consensual activity between Mr. Sanders and her that I believe she's now maliciously saying was a rape so that she can go ahead and do the civil suit, which I guess is going forward. I don't have any information on what's gone on in the past year. But, you know, the police only talked to her for 11 minutes. You know, we've hired a private investigator. He's probably worked on the case more than the state has in terms of the investigation, in terms of judging the credibility of what she said or corroboration. There's a rape kit done. Rape kit shows nothing. The only forensic evidence is semen alleged DNA on a towel that Mr. Sanders, or that she says is Mr. Sanders. Turns out that the testing says that it is. But like I said, Judge, there was a consensual commercial sexual activity. It actually involved Mr. Sanders masturbating, and she took money from him for that. And it was just something she was doing on the night shift. And she used that to bait him into, I guess, getting that DNA and making this allegation so that she could then get in on the lawsuit, which other people have got in on. It is a serious problem, but I don't think she's a real victim of that problem. She's a US American born person, as far as I understand. That the subjects of the lawsuit were undocumented, vulnerable people on the night shift that were raped by supervisors with a lot more authority than Mr. Sanders. You know, it wasn't like she wasn't going to work again in the airport if she didn't have sex with him. He was just one level above her. He wasn't trusted with much more than she was. And then when you see on the video, actually, they're both walking away from the room where the commercial activity happened. And she's laughing, smiling, does not look at all like someone that was just raped. And you'd think, too, that if the police actually took it seriously, they would have talked to her for more than 11 minutes. And further, when the raw DNA that GBI was a little bit difficult in allowing me to have, when this raw DNA came out, the actual picture of the towel shows what I think is splotches, not wipes, which is what she tells police. So her story doesn't add up. It's only gotten for 11 minutes, and the circumstances are fertile for someone like Mr. Sanders, who she saw as an easy target to then be taken advantage of. And the police just jumped to conclusions, basically didn't investigate anything besides the DNA on the towel. And again, talking to her for 11 minutes. And so I say all that just because I know the state is going to say the facts, but I'm really here just for a reduction based on the changed economic circumstances over this last year. He has been given a bond for $100,000, but has been essentially punished for not having enough money. And so we'd ask for a modest reduction, maybe down to like $60,000. That would still reflect the seriousness of the allegation, but that would stop this from being punitive based on money. And if $100,000 was a serious amount before the pandemic, I think with the high unemployment and recession and the difficulty it is in terms of getting a job and making money these days, that $60,000 hanging over his head would be just the same as $100,000 last year. And so given also that we don't know when we're going to trial next, he'll just continue to be punished for being poor, essentially. And so that's really not what bond is supposed to be about. It's just to ensure his presence back at court. He has no history of sexual offenses whatsoever. And so, Your Honor, we would just ask for a reduction. His already granted bond down to whatever's the lowest that the court thinks is reasonable. I propose 60,000 as a reduction.
Ms. Pitts, what's your response?
Your Honor, as to the facts of the case, Your Honor, I believe what Mr. Menendez gave the court were his opinions of the case. In fact, the facts are that this victim reported directly to Mr. Sanders. This was, in fact, the very first time they had ever worked together. She had been working there previously with other supervisors, and there had been no complaints. This was the very first time where Mr. Sanders had returned to this location, returned to this job where he encountered the victim in this case. All sum total, Mr. Sanders had been working at that company for a mere 3 months and had been out for a period of time and was returning and found a vulnerable individual. And I don't know that the fact that Mr. Sanders doesn't have sex in his history is as relevant as the fact that the court knows that rape is a crime of violence, and he does in fact have violence in his history. So in terms of the facts of the case, I believe the court denied bond on this defendant on February 28th of 2020, when the facts came out that the evidence is actually completely consistent with what the victim in this case reported on an immediate outcry to officers at the Hartsfield Atlanta Airport. What I would also ask the court to understand that this was a stranger rape, and that is what I think the court needs to consider in terms of the likelihood of committing future felonies, which would be the accurate way to talk about bond. Insofar as I don't believe any of the bond issues have changed, the defendant has a significant history out of New Jersey. I don't believe counsel made any reference to any ties to the community. What I show in his history is that he has several arrests and convictions out of New Jersey, and they are crimes of violence. Additionally, Your Honor, the victim in this case was a direct report of the defendants, and she made an immediate outcry. The victim in this case is 18 years of age, while Mr. Sanders is 45 years of age. I believe that under the circumstances and what the court considered when they set this bond, this being, I believe, the fourth or maybe the fifth time that defense has requested a bond modification or bond reduction, I believe that $100,000 bond, in my opinion, is low, but what the court has set under all of the circumstances, I would ask that if the court is actually going to give full consideration to modification of the bond, that the court would take into account the defendant's violent history, the age difference, the fact that the defendant was in fact her supervisor. I believe that's uncontradicted, and that this was a stranger rape. I would actually ask that the court would look at setting this bond at $150,000. I don't know if the court wants to hear about the state's objection to the out of time request for a speedy at this juncture or not.
No, today is the motion for bond reduction. If you want to argue that his speedy trial demand is out of time, do it in writing. And then I'll.
Oh, that's fine, Judge. It just says, it just says on.
I think it might, I'm sorry. I think my clerk put it on there as a reminder that this is a defendant who's requested a speedy trial so that we can keep everything in line.
Understood.
Okay. Did you finish your argument, Ms. Pitts?
Yes, I did. Thank you.
Okay, Mr. Menendez, you have closing on your motion.
Yes, Judge. Again, so I don't know what, even the bond argument isn't consistent. Is it a stranger? Is it a supervisor? And even if it is a supervisor, again, like I said, he's just 3 months on the job. It's their first time meeting. She's not the vulnerable one. He's not some Harvey Weinstein with, the keys to the airport. He's only worked there for 3 months, and it was an immediate outcry because it was a malicious attempt at targeting somebody vulnerable like Mr. Sanders, who nobody would believe after the fact, and that she could use him for this lawsuit, Judge. But all that to say that I do think that 100,000 is too much at this point. I did cite case law in my motion about the fact that not just the factors are to be considered in the amount, but also the defendant's ability to pay. And I think that between now and our last bond motion, Mr. Sanders has clearly demonstrated his inability to pay just by the fact that he's on the screen there in the jail and he's not here with me, Judge. And so again, if 60,000 is an incredibly serious amount of money to ensure his presence at court and to avoid him to continue being punished while he's presumed innocent. Of course, things can be consistent with something the complainant said, but that's why we have beyond reasonable doubt. And that's why, we have innocent till proven guilty, because I think the state here clearly fell victim to a confirmation bias when Mr. Sanders was targeted with this fake story. So, Your Honor, I think 60,000 would be a huge amount hanging over the defendant's head and his family's head. He does have ties to the community. He knows no other community. His wife is still with him and she's eagerly awaiting trial so they can be together again. And Your Honor, in the meantime, I don't think that 100,000 is reasonable for this particular defendant, and that he has demonstrated that just by his inability to pay over this past year since our prior reduction motion.
Request for a reduction of bond is going to be denied.
Okay, thank you, Judge.
You're welcome. Okay, last case. Shank Smith, motion for bond. Give me one moment, you all.
Towards me. That's good, that's perfect.
See, you speak English? Hello? Yama, along back. Okay, you have a consent law. Papeles para. Sí, para Yama, along back. Okay, no hearing point. No court date. Sí, en la unidad. Okay, contrato un abogado. Sí. I don't know. You hear the same thing, but that's not what I'm doing.
They're done with you right now. Just give it a moment and we'll send you back, all right? You see that?
That's not.
We can't discuss your case.
That's not what we get for, sir. Sorry about that. Yeah.
But she's done that.
She's done. Once she make her motion or make the decision, we can go back.
Okay.
But I didn't know she was gonna see him on like a lot of activity.
Understood.
He's,
Yeah, there's one coming in. We'll go.
sorry.
Next one, we'll send it back to you. Actually,
The last two.
yeah, we'll send it back to
We
you.
can just send this one back. Since she's doing it. Yeah, we'll go ahead on this.
Good luck, man.
You was. Thank you. Have a good day.
I think energy and his energy felt so like he was telling the truth, like he felt. I have this. Yes. And if they, whatever they say to me becomes part of the case.
Sir. Sir?
You gotta stand on the side.
Okay, all right.
He's been here a while too. I wanted to use him on my house when I was in CO. Do you consent?
Ms. Rivera, are you ready? You're muted.
Yes, and I'm ready.
Okay. State of
Okay,
Georgia. State of Georgia versus Shang Smith, case number 2021 CR 00988. This is a motion for bond. You may proceed.
Your Honor, this is a case stemming from a
You're muted. We can't hear you.
that was alleged to have taken
You're gonna have
place.
to start over because you faded out
Can you hear me?
barely. There's some background noise.
They're doing work outside. I apologize. This is a case that stemmed from an incident from April of 2020, where it was alleged that Mr. Smith assaulted his then girlfriend at the time. When the girlfriend sent pictures of a fight that she had the day before to a cousin. To her mother, the cousin that was present saw that the bruises that she sustained in this fight, and assumed that Mr. Smith was the one who assaulted her and called the police. When the police arrived at the location, his house that he was living with his mother, he and Ms. Korn were living with the mother. She informed the police that Mr. Smith was not the one who caused her injury. She informed the police that she had been jumped prior to, and conversations after the incident with Ms. Korn, she revealed that Mr. Smith was cheating on her. The girl that he was cheating on her with contacted her and made her believe that Mr. Smith was at her house. So she then in turn went over to the girl's house to confront the girl and him, as she believed that he was there as well. When she arrived there, the girl was there, and 2 or 3 other females were there. As soon as she got out the car, they jumped on her. She stated that in the text message that she sent to her mother, she never once mentioned that Shane Smith was the one who caused her injuries. Her cousin again assumed that he was the one that caused her injury because they had argued in the past. The police did not do a thorough investigation. They did not get any information concerning the fight that took place the day before. She said it was a apartment complex in Riverdale. Off of Riverdale Road. They didn't ask for an address. They didn't ask for the person's name. They didn't ask for the messages that were sent back and forth. They were told that Shane Smith did it from the cousin, and they took that and ran with it. When the police came to the door and asked for Ms. Korn, they were informed that Ms. Korn was not there. The mother, Miss Shane Smith's mother, did not know that Miss Korn was there. When the police came, though, and she had finally come out of the closet, they asked her why she hid. She said she hid because she was afraid. She doesn't like confrontation with the police. She didn't say because he put me in the closet. She didn't say because he told me to get in the closet. And even after Mr. Smith was arrested and taken away from the scene, she never made a disclosure that, no, everything I just told you was a lie. They did not jump me. He is the one who did this to me. He is the one who told me to hide in the closet. She has yet to change her story from the time that we've spoken to her a month after the incident. And the recent times we've spoken with her, she would have been here while I was attempting to get her here today. But when I called her last night, this case was put on the calendar yesterday. When I called her last night, she said she was at work and wasn't able to talk. I asked her to call me when she gets off. If it wasn't too late. And I'm guessing that it was too late because she did not give me a call back after I've spoken with her. And this was around 3 p.m. She said she didn't get off till sometime after 6. We're asking the state, this case was originally charged as a battery and an obstruction. The state indicted this case as an aggravated battery and a false imprisonment, which we feel like the facts of the case are an assumption of what they believe took place, an assumption of what a cousin believes took place with no factual evidence. The text messages we have not seen, as of course this case hasn't been arraigned and we have not gotten discovery. But according to Ms. Korn, she never said to her mother or to her cousin that Mr. Smith is the one that caused these injuries to her. And we asked for a reasonable bond of $30,000 that Mr. Smith, he has been sitting for over a year. In this case, he was arrested on April 16, 2020. This is now May, the end of May, beginning of June. And he's been sitting here waiting because they would not give him a bond in magistrate court because they would not set his case. And he just now got indicted. We had just gotten his case set on the magistrate court for the 4th of June. And now his case is indicted. So now he is here. And we asked for a reasonable bond considering the time that he's been sitting, the the way the facts are presented without an investigation, even though Ms. Korn is saying that she's repeatedly told the state and the police that he is not the one that caused her injuries. We asked for a reasonable bond so that he may get out and fight his charges on the streets. His mother does still live at the same address, so he does have ties to the community. And from what I'm understanding, Ms. Korn is not even in the state. She is back in Florida at this present time. And for as far as him being able to make the bond, his family has been working on that. We just need a bond to be set, and it's been a long time coming. We are finally at a point where it's been indicted, so he can get a bond now on the charges that the state were trying to present him with. And we just asked for a reasonable bond of $30,000.
Ms. Miller?
Your Honor, the facts of this case, for some background, is that on April 16th, 2020, officers responded to 235 Country Club Drive in Clayton County in reference to a domestic disturbance. They had received a report from the victim's cousin that the victim was being beaten and held against her will by the defendant. When law enforcement arrived at the location, the defendant initially denied that Ms. Korn was present there, but officers did subsequently discover her in the defendant's bedroom. At that time, she had severely swollen eyes, a bleeding lip. She had extreme bruising on her arms as if she had been restrained, as well as redness around her neck and upper chest. They then subsequently transported her to the hospital due to some apparent facial injuries, and hospital records show that she actually had a closed fracture of her nasal bone. All of that stemming from an altercation with this defendant. He does have prior criminal history, including a 2004 aggravated assault that was when he was a juvenile, a 2011 drug violation and simple assault, 2014 conspiracy to distribute drugs. Your Honor, he also did have a failure to appear in 2016, as well as a 2017 possession of a firearm by convicted felon. Taking into consideration his history, the gravity of these offenses, Your Honor, we do believe that he does pose a significant threat, particularly to Ms. Korn, not only as a person in the community, but also as a witness against him should he be released. We also do believe that he has a risk of not appearing if released on bond due to that prior failure to appear and his criminal history. And so, Your Honor, the state in this case, we did make an offer to Ms. Rivera. She did deny that offer. And at this time, we're asking for a bond in the amount of $65,000. We do feel that takes into consideration the time that he has served. Your Honor, also, just so the court is aware, this case was presented to the grand jury on May 18th. They did true bill the case, so it will be going forward and has already been indicted. We'd ask for special conditions on that bond to be no contact, obviously, with Ms. Korn, stay away from her as well as any relatives, and that he submit to a curfew.
Ms. Rivera, you have closing on your motion.
It was a few things that Ms. Miller stated as far as the police transported her to the hospital, that she was actively bleeding. None of that is reported in the police report. In fact, the police report states that Mr. Smith's mother took Ms. Korn to a friend's house at her request. It states nothing about her being taken to the hospital at the time that the police was called. It says nothing about her actively bleeding at the time the police was called. They did have the county photographer come out, so we expect to see the photos from this incident in the discovery packet. Again, like it's first and most importantly, Ms. Korn is not even in the state for him to pose a threat to her. We think $65,000 with the fact that he's been sitting for as long as he has, and this is all from an allegation that was made by someone else, not Ms. Korn, but someone else, that he committed these offenses towards her. We ask that we get a reasonable bond with the time that he's been sitting, with the time that the lack of actual information, with the fact that Ms. Korn is not in the state. We ask for a reasonable bond of $30,000 so he is allowed to fight his case from the outside and not be in the confinements of Clayton County Jail.
Court will set the bond at $50,000. I'll prepare the orders. That concludes all matters for today. You all have a good day, and whoever is going to appear tomorrow or Friday, I'll see you then.
Thank you, Judge.
Thank
Thank
you.
you. Jen.